Okay, good morning. My name is Dana Schmidt, and welcome to the AOC's Rule 38 training. Um, as Program Manager for Mediation and Grants, I thought it would be a really good idea to share the benefits of Rule 38 and how, as a mediator or parent education provider, that you could receive reimbursement through Rule 38 and the Parent Education and Mediation Fund. Also, I have many of you may be familiar with is Noelle Weldon. Noelle is the program's assistant, and she plays a very important part in our office as she is the first person who receives your billing and makes sure that it's processed and forwarded to me so that I can send it to fiscal so that it may be approved for payment. And that's anything to do with mediation or parent education. So what we'd like to do is first thing, housekeeping. This is being recorded, so we will post it. You will see at the end to the mediation webpage related to Rule 38 at the end. So if you have colleagues who can't make it today, this is going to be shareable. Because we're recording it, we would ask that all questions be submitted in the chat. That way, those who review the training in the future will also receive the benefit of your question and answer, which I think is always great for everybody. And then 3, I have, if you will look in your chat, I just sent the PowerPoint out in PDF form. If for some reason you can't open it, you can't get it, we are happy to share it with you via email, and we will also be posting this on the website. So you will have different ways to access this. So just a little background. The AOC is charged with administering 2 very important grants that are created by statute. And one of them is the grant we're going to talk about today. So I'm going to get the PowerPoint started. I think we're right on time. I would like to keep this at 30 minutes because it is being recorded for future reference. So anything that we can't cover or can't get to today in 30 minutes, you're welcome to email me or Noelle after, and we will talk to you, work it out, answer your questions the best we can. So a little bit of background on Rule 38. It's very interesting, and I'm not going to go over this and read all of this, but Rule 38 funds come from a statutory fund set up by the legislature. It's called the Parent Education and Mediation Fund. And so the legislature thought this would be important to assist divorcing parents. And what's very important is the funds don't only apply to divorcing parents, they also apply to non-married parents. And the AOC uses this funding to create grants that we provide to nonprofits and court programs to assist in their efforts to provide mediation services, parenting education, visitation, and so forth. But another source of funding that PMF provides is the Rule 38. So in order to carry out the business of the PMF fund, the Supreme Court created Rule 38. And Rule 38 says, here's another way that we can utilize the funds from PMF to providers in a much quicker way so that the courts have obviously other tools to use. So that's the whole point of this. The Supreme Court has this money, and then we want to be able to disseminate it to service providers across the board. It's interesting, as long as people get married, we will have this fund. The last bullet point there, if you'll see, it says $7 of every marriage license fee is paid to us towards the PMF fund. So as long as people are getting married, we continue to have this fund. It does fluctuate every year for that reason. We have never not had a PMF fund since it was instituted, but projecting it is really dependent on what we don't spend, and that's the blessing of a state grant is we don't lose the money if we don't spend it. And so Rule 38 and PMF grants all come from this particular source of funding. The type of cases, this is very important. If you're interested in providing a Rule 38 service, it only covers two, according to the rule, two types of services: mediation and parent education classes. The party types are important. It can be divorcing parents or unmarried parents. In juvenile court, Rule 38 can be used for parent, and you're going to have non-parent, because there's a little piece at the end of Rule 38 that says, and other custody matters. And the AOC has interpreted that to mean non-married, married cases. So this is how we're able to provide funding to juvenile court in those cases. What's very important, though, this is income-based. So there must be a finding that the parties qualify for either indigent or low-income-based services. That's very important. How do you qualify for Rule 38 funds? The best thing about this is, unlike grants, when we offer grants, you do not have to have a contract to qualify and be approved for a Rule 38 service. This is a direct court referral and reimbursement. If you are a Rule 31 mediator, a listed mediator, the way you provide the service is the court refers a case to you as a listed mediator. Rule 31 requires courts to refer cases to listed mediators. Parent education classes, this is through each court. So every court can have a different criteria. But if you want to be a provider, you're going to go through the court as well. Mediation referrals. Let's start with mediation. If you're interested in providing mediation through Rule 38, the first thing you need to do is secure a court referral through a court order. This is much like court appointments. If any of you are court-appointed attorneys, it's the same concept. So you're going to have the court send you an order that says, I'm referring these two people to you for mediation. I found them to be indigent or they qualify for low-cost mediation. If you are not listed and you mediate a court-referred mediation, you're not going to qualify for Rule 38. My job is to vet those requests for payment, and that will be the first thing that I look for, and it will cause you to be disqualified. So if you are not listed and you receive one of these referrals, you have a duty to notify the court that you're not going to be able to receive reimbursement, but you can still provide it. But you won't be paid through Rule 38. And then sometimes a referral order is known as an order of reference. I'm used to calling it a referral order. But again, this is the piece that will be required in the first step of claiming your funds. Parent education. This is strictly through the court. The AOC has no decision in who is approved as providers. Through experience and working with courts and talking with judges and court administrators, some courts may have a set of criteria. They may have minimum requirements they want in their curriculum. They may want you to submit a whole packet before they approve you, but this is specifically court approved. So you're going to be looking at any court that does custody. It could be Chancery, Circuit, Juvenile. Again, the court usually will have a list, and then when the court deems parent education is necessary, they will pick a provider from the list. Do you want to become a provider? The first step in becoming a provider is you need to contact the court you want to serve. Usually, how do you do this? Usually a court will have an administrator or someone that's in a position like an administrator. That's what you're going to need to do. I would suggest you call the court, maybe ask for a meeting with the administrator. These individuals are usually very busy, so you're probably going to want to ask for a meeting and be prepared to present your packet. But I just say, call the court, ask to speak to the administrator, or, the person who oversees these types of things for the judge or the judges. That's where you start. And if they don't handle it, they will send you to the right person. In my experience, I mean, I've done this type of work for 20 plus years, and my experience has been the judges are very open to receiving any type of tool that's going to help them move their cases along and meet the needs of the people that are on their dockets. So don't be hesitant. If you think this is something you want to do, that's where you start. If you call me, that's exactly what I'm going to tell you to do. Sometimes we have a list of the administrators. So if you're not sure, that's what I could help you with. You could give us a call and I could see who possibly I could direct you to start the process. How to get paid. That's a big part of this. So Rule 38 sets the maximum fee amounts. This is very important. So for Rule 31 mediations, the rule offers up to $25 per party for the hours spent in mediation. So this again is if you're a court-appointed attorney and you submit a bill, you always talk about in court, out of court, and other expenses. Same concept with mediation. So for every hour you're in mediation, you can charge up to $25 per party. So it's going to be a max of $50 an hour for every hour spent in mediation. If the court finds that each party is 100% indigent, and that's what I mean by up to. I have courts every day that will say, I find that the father can pay $15 an hour and the mother can pay $0 an hour. Then what happens is we pay the difference of the 15, if that makes sense. So we're going to come up with the other 10. So what does that mean for you? You are being responsible for obtaining the $15 from the party who was ordered to pay you 15. That is not the AOC's responsibility. The rest you are going to submit to us through billing, and we will pay you for that. I've had that happen a couple of times where the mediator didn't understand that we have nothing to do with what the court orders the party to pay directly to the mediator. That's between the mediator and the party. You also can be paid for out of mediation planning. So it's the same again, like attorneys. So if you take 3 hours to plan the mediation, which means calling, setting up appointments, reviewing court records, talking, all of those things that are considered mediation prep, you can receive, based on the court order, up to $20 per party or $40 total an hour. So if you spend 3 hours prepping and the court finds that both parties are 100% indigent and can't pay, then you're going to get $40 per hour. And that's going to be $120 that we will pay you based on the records you submit. Reasonable costs and expenses. Rule 38 is a little vague on this. It does, when you read it, gives you some examples. For example, travel, printing. I have one attorney in East Tennessee, one mediator, who charges for space rental. You say, well, how does that work? He rents a conference room. And then let's say it costs $200 a day to rent the conference room. What he does is for every mediation he spends, then if it takes an hour to mediate, then he charges us that hour's rental time for that specific mediation. We do not pay the entire day, but only for the time he uses to mediate a Rule 38 mediation. So usually, and I can tell you, usually it's $25 or $26 for the time. But because this is broad, what I would say is I have a little more ability to consider what's reasonable costs and expenses. Always ask first. If you're thinking, I don't know if this is covered, the best thing for you to do is email me and ask first, because if you put forth the expense, you pay it, and then you send it to me and I don't approve it, you're stuck. There's nothing wrong with asking before you spend the money to ask me, is this going to be covered? Parenting classes is a little bit different. So if the court orders the parent to take the class, and anywhere from the court can find, they can pay up to $25 per parent, then the most you're going to be reimbursed is for whichever parent you provide the class, could be $50. My experience is sometimes parents, one will show and one won't show, so the referral says to provide the class, you provide the class, you can bill the $25. And then the $25, this is important, also covers the time and materials spent providing the service. So unlike Rule 31 mediations, you don't have the ability to carve out your costs and expenses. It's going to be included in the $25 per person. Again, the court may find that the mother can pay $10 and the father can pay nothing. And then again, we will pay you the $15 and the $25 for the father. How do you submit a claim? Right now, our process is we provide you the documents, you complete the documents, and then you email them to this email right here, grants@tennesseecourts.gov. It's pretty simple. Again, if you did any court-appointed work, it kind of looks like the old way of doing that. I know now everything's digital for court-appointed attorneys, but it's still the same concept. The very most important part is you've got to have that referral order from the judge. That's the first thing I look for, because that is what gives me the authority to pay you these funds. It's very, very important that the referral order be signed by the judge. We'll look for that. If not, we'll send it back to you and you'll correct it. Then the Rule 38 mediator invoice form, we're going to show you what that is, but this is the form where you document the hours spent, the time you're claiming, and this also must be signed by the judge. And we'll show you that. Very important. So basically, that's your checks and balance that I'm going to be looking for. Little bit, it's the same with parent education claims. So you're going to have that referral order from your judge, signed by the judge. And then you're going to have an invoice. And basically the invoice again is going to show, now this isn't signed by the judge, but this is going to show who attended, when they attended, and those types of things. So that's the basics for parent education claims. Now, we're going to show you the forms. Noelle's going to share those with us on her screen, and we're going to walk through those. So this is the link, this is an active link for you. This is where you go on the AOC's website to access the forms, is this page. And it looks like this. So when you get to this page, here's what you're looking for. This is the mediation page. If you scroll down, you will see forms and invoices. There's a whole section dedicated to those who want to participate in Rule 38, the forms and invoices. These have all been approved. You can, some judges take them, they leave them as is. We have some judges that make them their own. That's absolutely their prerogative to do so. But what we're looking for is specific language and a signature. So these are all here for you. If you go up at the top, I wanted to show you if you're going to do a mediation. Again, even though this is referred from court, all of the, your mediation agreement needs to be there. Those types of things, your report forms. So they're also located on this page for you. I would advise everyone, you always have an agreement to mediate to start off with, because you're a Rule 31 mediator. This also, Rule 31 provides a grievance process for parties to make complaints against Rule 31 mediators. And one of the first things we will ask for is, was there agreement to mediate? Because that defines whether it's a Rule 31 mediation or not. If they're not under Rule 31, number one, you're not going to get reimbursed but two, the ADRC is not going to review your case because it's not a Rule 31. So those are very important. So just to bring your attention to the fact that there's these other documents that are also available for you and that they are compliant with AOC rules and court rules. All right, so here's the location for the documents. These are all active links. Noelle, do you want to share the each one so that we can show them what it looks like?
Yes, you'll have to unshare your screen.
Yes.
Can you guys see my screen?
All right, we see it. So
Yes.
this is yes, so this is a first order form order that you are welcome to use. It's prepared, it's ready to go. Like I said, your judge, more than likely, if your judge has done this in the past, already has this on file, but you can share it with the clerk, the judge's assistant, the judge's clerk, and they're welcome to make changes. If you need our assistance, we can transfer this into Word or whatever you need. We'll provide technical assistance because it's our order. What's important is when you take this case, the judge orders the mediation, the judge needs to make a finding of what the parties can pay. And that is where Noelle was pointing to, ordered that in each one of these boxes need to be checked. So we tell us what the plaintiff has to pay, if anything. It could be $0 an hour. That's fine. And then you go to the defendant, what they're going to pay could be $0 an hour. And then anything not covered, and then it goes on to tell you what out of session will be. So it tells you, again, like I said, it could be 0 up to 40. The judge may find one party can pay their whole side of their entire cost. That's fine. That's and then what is very important is it says the balance of the plaintiff and or defendant's mediator fee in this case shall be paid from the PMF fund. This also has to be addressed because the balance that's not addressed at the top between the parties is what we're going to pay you. So that's probably the most important paragraph in the order, and plus, of course, the judge's signature. Okay. The next one is going to be the reduced. Okay, and so this is what the invoice looks like. It's fillable. If you don't like fillable and you like to hand sign, fill it in, that's fine. We take that either way because it has to come back to us in a PDF. So if you want to print these out, sign them, fill them in, do your thing, that's fine. But this is the form you need to submit. Once you input all the data at the top, again, this is going to have to be signed by the judge before it comes to us. So this is the first page. This is what we look for to make sure the parties and everything is correct. The second page is very important because this is where you're going to show your activity, the day you did it on, what you did, and then were you in session, out of session, and your expenses. This is very important. And then you're going to add it at the bottom. So page 2 totals need to match page 1. And we do make sure that that happens. Everything needs to add up. Usually what we'll do is, I don't think it's fair to reject and say, oh, well, your top page doesn't match your bottom. Usually what we'll do is I will email you and ask your permission, point out what I think is an error, and then ask your permission to make the change. Why? Because that expedites it and gets it going. If I just reject it and send it back to you and you missed your email, those kinds of things, we don't want that for you. You're already doing this at a low cost for the court and for the AOC, so we don't want to hold your payment up. But what's really important is no identifying information, even if it's circuit. It's fine if you want to put initials for parents, that's fine. First initial, last name. I prefer no identifying information, especially for juvenile court, because I have your docket number at the top. So if I've got your court and your docket number and there's ever an audit, I just ask the case by the docket number. And if the docket number is correct, then I'll be able to match and do what I need to do. So that's the forms for mediation. Now, if you want to be a provider for parent education class, this is the order that we offer that you can take to your judge as well. It's as you can see, looks familiar, same thing. The judge just needs to order his or her findings as to what each party will pay. And then because the rule sets the amount, then what is left over, we will pay. Again, as long as the language is there and those pieces of information can be plucked from the order, how your court wants to change the order is up to your court 100%, not an issue for the AOC. And then the invoice looks a little bit different, as you can see. This is what you're going to fill out. So, of course, this is designed if you offer a class, like some providers will offer the class every 2 weeks, once a quarter, depending. So this is made to where you can bill all at once. So if you have 3 classes and 12 attendees, if you wanted to hold it and you do it all at once, you're welcome to do that. Okay, so Molly asks a question. Where was the chat? Let me pull Molly's chat back up. Okay, for mediation reimbursement form, did you say we don't need to get the judge's signature? Is that something the AOC does or the mediators does? No, you will take your invoice or email your invoice. The judge also has to sign off on your invoice, approving your work. Noelle's going to take you back real quick. There's actually a judge's signature. So the mediator signs, and that is
set up. Yeah, we need people.
okay. So you sign the document stating that you attest that everything's accurate and you're telling the truth, and then the judge will approve it, just like any other court order cost. So yes, Molly, you do have to have the judge sign off on your invoice. And that's the one thing that if it's missing, I'll have to send back to you because of course I don't have permission to sign that. So always double check and make sure you've got your judge's signature on your invoice before you send it to us.
And the order.
And the order, yes. Okay.
Candace has a question.
All right. Who has a question?
Candace?
Yes, good morning. I don't know if I need to wait until the end to ask this question, but speaking in terms of the mediators list, what I have found is that a lot of the courts now have their own mediators in-house, and they do not have a mediators providers list. So I'm trying to see if it's law that is it law that they have this list? And how are we now to serve clients if the courts now have their own mediators on staff and they're not sending out referrals?
Candace, what I can tell you is not every court has in-house mediators. So that's what I can tell you. Nothing requires the court to use Rule 38. What Rule 31 requires is that a court refers mediation to a listed mediator. That's what the rule says. So if the court has employed listed mediators on staff, then, and it's what they choose to use, then they're in compliance with the rule.
Okay, and my second question is, I know that a lot of organizations, I guess they're nonprofit organizations, now have mediation training centers. And I guess if you're not a part of that particular training center, of course, they're using in-house. So in essence, what I'm saying for those of us who are trying to provide services, we're running into these kinds of barriers and challenges because it seems like everything is kind of cliquish, so to speak. If we have so many parents going through the courts needing the services, it's more than enough mediators to provide it. But if it's only going to a select few, then Is there something that we could do or the AOC could do to make it more equitable for all of us to receive clients?
You know, what I can say is the first equitable thing the AOC does is it provides the list to the public. So if you're a listed mediator, that's one of the benefits is that you automatically are posted to the AOC's website, which is available to everyone, not just the judges. So the AOC does that. But as to what independent nonprofits do and the courts do to run their administration, that is between them. The AOC is focused on providing, you know, ways for people to receive services. But what I would do, Candace, is I would reach out to the community mediation centers across the state. We have more than one. There's one in Nashville, Nashville Conflict Resolution Center, but we have more than one. And the good thing about, if you said, was there anything good about COVID? What it taught us was there's more ways now to reach people than just in person. And so mediators now can mediate a case in Memphis from Chattanooga. So I would reach out to the directors for those CMCs, and that's where I would start. And we have all of the CMCs also listed on the website with a link to their offices so that you can call them directly and email them directly. And I have a list of the directors, and if you're interested in a specific CMC, I am happy to share their email with you. And I know that they would be happy to hear from you because a lot of their work is volunteer, and they don't keep a large number of mediators on staff. So Rule 38 is also a benefit as well to them. Anyone else have any questions? I hope this was clear as mud. We just wanted to give you a brief overview. You can find on this webpage under rules, you can find Rule 38. I would recommend that you read Rule 38 as well. Noelle, if you'll go over to the left under rules and click on rules. Yes. We have Rule 38 under this section as well. And it gives you an overview of the very specifics. I did not give you uber details because I know you all can read this, and as you can see, it's a lot of detail. So I wanted to give you a 30-minute overview so that we could get the word out, because I can tell you as the person who approves these invoices, we do not get a lot of Rule 38, and the money is there. So I am not saying hold back. If you can find a way to utilize it, please do so. And then we will walk you through what you need to make it happen. Another question, how do mediator payments get made by check? So everybody who wants a check from the state of Tennessee has to become what we call a vendor. So you're going to have to submit a W-9, and then you're going to either ask to be paid by check or direct deposit. And that's through F&A, the finance department. So that's the first thing. So if you've never billed with the state of Tennessee before, we will help you set up by giving you the most current W-9 and then the process so that you can have direct deposit. I strongly recommend, if you can, do direct deposit, because if they issue a paper check, it's a longer process. And if we have an issue and you're only paid by check, it's going to take even longer if your check is held up, whereas direct deposit obviously is very quick. So I don't recommend, if in any way you can, do not be paid by check, because it's like snail mail.
I
No,
attached the W-9 if you guys are interested in it.
yes, if you have not been a vendor, Noella shared the most current W-9 that F&A requires in the chat, and it's there for you.
It has to be hand signed. You can't digitally sign it.
No, they will reject it. It has to have everything specific to your tax ID number. So whatever you have, on file as the name, address related to the tax ID number you put on this form. It all has to match, and they will reject it. So make sure everything matches what you've already told the IRS.
And then whatever you guys put here in the address has to match your invoice form as well.
Does anybody have any questions? I'm 5 minutes over. Okay, again, all right, great. If you need anything, the last page of the handout's got my, let me share that, Noel. It's got our contact information. So here you go. So there's my name, Noel's, our email, and our phone. I'm telling you, email is the quickest way to reach us. I can easily return emails on my phone while I'm taking the dog to the vet. I can, emails 24/7, phone, it's through the extension, and we have to be logged on. It's not the fastest way to get us. So, and usually if you leave me a voicemail, I'm going to respond in email so we have it in writing, because it usually entails some type of instruction or direction or information, and that way you'll always have it to refer to. All right. That concludes our Rule 38 overview training. Like I said, if you need anything, you know where to find us. We will be posting this on the website, and thank you for attending. Noel, we stopped recording.